evening, one and all.
Yes. Good evening.
Yeah. And good evening to Mr. S.P. Shankar, a senior advocate who is known for his knowledge, especially on the civil side. Taking into this consideration, we requested Mr. S.P. Shankar to give and share his knowledge on a topic which is quite close if one who deals on the banking law side, that is wherein Securitization Act and the Debt Recovery Act of 1995 comes into being. What is the interplay between the mortgage, the Securitization Act and the Debt Recovery Tribunal Act 1995 is quite a fascinating topic for the purposes of as a professional if we understand, but also for the banking professionals and the persons who have given the property on mortgage. But mortgage is not simplicity restricted to the banking industry as such. But there are different types of mortgages and what is the effect thereof, and especially since we have taken the topic of law of mortgages with special reference to banking law. What is the effect that once the account becomes the non-performing asset, in short, what we call as NPA. And in case there is a default and the account becomes NPA, and as though it is not the part of the topic, as to if the property is to be sold, what are the provisions under section 13, 14 and section 17 of the Securitization Act is another aspect. We have already done 2 webinars on that aspects of Securitization Act by Ma'am Nandi Gomti and Justice K. Kannan, a former judge of Punjab Haryana High Court. So those who are watching us, they can look into the at PEEP for further knowledge on that aspects. But since there is an interplay of today's session between the mortgages with special reference to banking law, we thought there could be nobody better than Mr. S.P. Shankar. Whatever little interaction I had till the time which I made a request and thereafter, I found that he's profusely deep into the knowledge and taking better knowledge put forward. With these all aspects, we requested him, and as we always say that the resource persons have always been kind enough to agree to come on our platform to share the knowledge. And I can say with all humility at my command, Mr. S.P. Shankar also accepted to come on the same page to share the knowledge on a fascinating topic. Without taking much time, I would request Mr. Shankar, whose notes we are already sharing on the WhatsApp groups, and those who have not joined our WhatsApp group, they can just send a ping on the WhatsApp. We will share the notes shared by Mr. Shankar, coupled with the YouTube link, which you can always share, like, and subscribe of Beyond Law CLC. Over to you, sir, and we are glad that you accepted our invite.
Thank you very much. Good evening.
Good evening,
and
sir.
I'm happy to deal with this subject in the real perspective. I'll be dealing with law of mortgages and a few sections of the Transfer of Property Act, the common law. And then I'll go to Securitization Act, read from section 13 to 17. And then I will also go to section 108J in particular reference to the right of the lessee to mortgage his interest in the leasehold rights. This is how I have distributed the time of 1 hour for discussion in the evening. Let me start with the common law, namely Transfer of Property Act. The banks have taken this important role in our trade and commerce. Banks always look to the security aspect before considering the loan proposal. The loan proposal is based on credit report of the borrower and on the security that he proposes to furnish. Title is inquired into and a report is obtained by the bank, and thereafter they would go into the security of the value, intrinsic value of the security, and then deal with the documentation. Now, in regard to the documentation, the discussion commences now. Section 58 of the Transfer of Property Act defines the mortgages. We have different kinds of mortgages: simple mortgage, usufructory mortgage, then this anomalous mortgage, deposit of title deeds referred to as equitable mortgage. The easiest way is to have the deposit of title deeds as security for repayment of the loan. This transaction is called equitable mortgage. For purpose of the reducing the cost and the volume of the documents, they always make a record of the fact that the documents of title of the borrower are deposited with the lender, namely the bank, only for the purpose of creating security on them and nothing else. Conditions of the grant of loan, the terms of the contract, the rate of interest, the amount borrowed shall not be mentioned. If it is mentioned, it requires registration. This is the first hurdle the banks will have to see for itself and then proceed in the matter of processing the loan papers. We have section 58B. We have section 58D of the Transfer of Property Act, which deals with these aspects, and the collaterals or the security offered by the borrower will have to be scrutinized. Then one of the aspects that we'll have to look into is how this mortgage is created. The equitable mortgage is created not by a bigger, a detailed document of mortgage, but only on a small piece of paper. They use this expression. We put on record that we have deposited our title deeds in respect to the property mentioned in the loan application only for the purpose of creating a security on those documents on the leasehold rights and for to see that the loan is repaid. This is the special device that the bankers have innovated and which has come into existence. The one question arises: does this document require stamp duty? Does this document require registration? And what are the terms to be incorporated? The answer to these three is yes, the same. It does not, the document does not require registration, does not require stamp duty, and shall not, and for no reason, the terms of the contract shall be entered into in this memorandum of deposit of title deeds. We call it as memorandum of deposit of title deeds, or a small memo saying that we write to put on record that these documents are obtained for the purpose of creating security of the document loan, the property in the possession of the borrower, and there shall be a charge in the same. Now we'll have to see the distinction between the actual proprietary rights and the interest of the borrower in this interest, quote and unquote interest. The leasehold rights or the interest of a tenant. Let's see. The interest to use the property is also a valuable security. The persons who borrow money need not necessarily be the owners. This is the context on which I'm saying that the limited interest or the enlarged interest. For example, I will perhaps start with the mortgage of deposit title deeds of the leasehold rights. Now, a doubt will arise whether this has happened in courts. That's why I'm saying that the doubt will arise as to whether the leasehold rights would themselves constitute security for purpose of borrowing. And that has been answered in different ways by different courts. But the position of law is this, namely, if a person is lessee in respect of an immovable property, in terms of a registered deed of lease, that lease deed itself is a document of title, and the interest of the borrower is represented enough in the document of title. That document is capable of assignment, is capable of mortgage, is capable of sublease. The right title and interest of the lessee consists of the leasehold rights, which are in his favor, his right to assign the same in favor of another person for raising funds, his right to mortgage this bank, and lastly, the right to grant sublease to the leasehold rights. These are the three dimensions. The earliest decision that came into existence in regard to the right of the lessee who has in his hands or in his possession the leasehold rights to mortgage, to assign in the decision of the Supreme Court reported in AR 1952, SC page 156. Under the Rent Control Act, eviction proceedings were laid and the leasehold rights had been assigned by the tenant who was a lawful tenant in favor of a third person. The issue was resolved by the Supreme Court to say that the lessee has the right to grant sublease, has the right to grant mortgage, mortgage the property, and has the right to deposit the leasehold rights itself as an equitable mortgage and create the charge on the property he holds. This how this property. The next question is, if the lessee can create charge on the property in terms of the section 58, namely equitable mortgage, what is the role of section 108J? It came up for consideration, and as I submitted to you that 108J authorizes in specific terms, lessee may transfer absolutely, look at the word absolutely, or by way of mortgage or sublease, the whole or any part of his interest in the property, and may and any transferee of such interest or part may again transfer it. The lessee shall not, by reason only of such transfer, cease to be subject to any liability of the attaching to the lessee. So it is clear from section 108J that a lessee may transfer absolutely or by way of mortgage or by sublease. Therefore, the decision of the Supreme Court, which was rendered in 1952 Supreme Court, page 156, is to the effect that assignment is valid and assignment is permissible and assignment is binding on the mortgagor, the owner of the property, or the lessor, the owner of the property. Now the question is whether 108G overrides other things. Yes, in fact, the provisions would say that the Transfer of Property Act is also central enactment, and this Securitization Act is also the central enactment. And since both of them, this common law has continued to exist and is served by the Constitution, there is no repugnancy, and all of us are safe by saying that this sort of mortgage is valid in law. Now we'll have to kindly see the position as it has improved. The position is this: equitable mortgage is and shall not be a document containing terms of loan like the amount lent, rate of interest, or other terms and conditions of the loan. An equitable mortgage merely consists of a report or a writing by the borrower affirming that he has deposited the title deeds with the intent of securing loan and creating charge on his interest in the property, and more importantly, recording the fact that he has delivered possession of the deeds of title, nothing else. So we will see that by fiction, equitable mortgage can be created by deposit of title deeds. We'll have to, this comes under section 58 clause D. Then we'll have to see as I narrated to you earlier, that this document of equitable mortgage does not require registration and does not require stamp duty. We have always, we lawyers look for an authority to support our argument to say that it doesn't require stamp duty and registration, and we can rely on this decision. The earliest decision is AER 1950 SC page 272. After 15 years, the law was again declared in AER 1965 SC 1591 to say that equitable mortgage does not require stamp duty and it does not require registration. Karnataka High Court has also held that memorandum of accompanying the deposit of title deeds contains only a statement that a deposit is made by way of security for repayment of loan and it does not require registration. So the question is in all the high courts, and the law continues to be the same even now. In the year 2004 also Supreme Court has held likewise. Therefore, we can comfortably feel and feel assured that the document of equitable mortgage does not require stamp duty and it doesn't require registration. Then you will kindly see at section 58D makes a specific reference to a few places in India where this type of mortgage can be brought into existence. The banks are authorized to take deposit of titles not throughout India, but confined to a few places which are enumerated in section 58D and which have been subsequently added on by Gazette notification under the provision of section 58. Now, however, the banks are throughout India are operating and they are granting loans. A question arises for consideration whether a property situated in places other than the enumerated cities in section 58D can be offered as security for as an equitable mortgage and loan be secured. The answer is yes, it can be done. The deposit must be made in those cities deposit need not be made in the place where the property is. So therefore, the borrower can go to the office of that bank where in the place where that city is included in section 58D and create mortgage by deposit of title deeds and secure the interest of the bank and also avail loan. This facility has come by reason of certain fiction created by the think tank, namely the advocates. They were there earlier. Deposits should be made in these cities. The property need not be in those cities. The law doesn't insist that the law must be, properties also must be situated in that city. So therefore, the ingenuity of the lawyers, they were the bank lawyers as well as the borrowers, lawyers and the borrowers, it has resulted in this situation, namely, irrespective of the place where the property is situated, mortgage deeds by deposit title can be created and in those enumerated places. It's a very safe thing to do this, and this has been done. Then we'll have to go to the kinetics of the term mortgage. What is mortgage? Mortgage is a transfer of an interest in immovable property. Repeat, a mortgage is a transfer of an interest in immovable property. The immovable property has to be and is always specific. Mortgage could be to secure existing loan or future loan. See, look how the community of lawyers who are assisting both the bank and the borrowers have evolved a new method that it's a transfer of interest in they have to be specific in regard to the mortgage property, and it could be to secure the future debts or the existing debts. This is how these three enunciations will show that the law is made by extending the scope of section 58D to other areas, and we are in such a position now that the mortgages can be created for purpose of securing the interest of the bank and also for securing the interest of the borrower. Now, see, you have understood that mortgage is by deposit of title deeds. The sufficiency of the security is the next issue. If the mortgage property does not yield enough security, does not help the bank to realize the whole of the money lent, then what is to be done? The personal liability of the mortgagor is also to be incorporated as one binding him and securing the interest of the bank. So in addition to the deposit, memorandum of deposit title deeds, the bank will obtain loan documents like pronote, promissory note, a memorandum of understanding and other securities to see that the loan is for existing loan or the future loans and the property is situated, and not only that, the borrower personally undertakes to repay the debt if the security falls short of the debt due from him. This is an exceptionally well-balanced view of the learned advocates, and assistance given by them is to be appreciated. I think as far as the deposit of title deeds are concerned, this will be sufficient to say that it should be a mere report of the deposit of title deeds, expression of the interest, the intention of the borrower that the deposit title shall be charged with the liability to pay the debt, and that he would be personally liable for the amount in excess of that. He has to show that documents are mortgage and deposit title deeds to be said to be covered by our discussion. We have other documents, the simple mortgage, it requires registration. The usufructuary mortgage, where the property is delivered to the mortgagee, and he enjoys the profit from interest from it or the income generated from it, and he surrenders back the portion of the debt is discharged. Then we have that English mortgage, which is slightly peculiar, and there the transfer is absolute in the English mortgage. We have in contrast mortgage by conditional sale. Mortgage by conditional sale is a peculiar type of document where the borrower stipulates in the same document contemporaneously that he's actually selling the property, and if the loan is discharged within the time stipulated therein, the property shall be reconveyed to him. So this mortgage by conditional sale and reconveyance is incorporated in one and the same document, and that's the next security. The anomalous mortgage is not adhered to by any of the banks, and anomalous mortgage is really anomalous, and it doesn't help anybody. So the other types of documents are essential. Now, having crossed the threshold subject of the security in the form of mortgages, we'll have to think of the other provisions in Chapter 4 of the Transfer of Property, the Common Law. We will be invoking the provisions of Section 67, 67A, 68, 69, 69A, 79. We'll have to see how these provisions, special provisions are applicable in the mortgages. The right of the mortgagee to sell the property is one of the ingredients of common law. Now that common law right is transformed into a specific right under Section 13 of the Securitization Act. We'll deal with it a little later. So the rights of the mortgagor and the mortgagee, the liabilities of the mortgagor are enumerated in certain provisions of the Mortgage Transfer of Property Act, and that will help the banks to secure its interest fully. We have covered the aspect of how to marshal the contribution and the realization from mortgage property by referring to these sections. Then we'll have to see the common law liability or common law rights under Transfer of Property Act was to file a suit for foreclosure or forfeiture, and therefore it involved litigation in common law, payment of court fee, ad valorem court fee, and the claim made, the elaborate and laborious, indefinite, interminable execution proceedings, and the borrower would not be, the lender would not be there to realize the fruits of the decree, as many of us know that law of execution is dedicated to a few persons like the process server who never executes the warrant, the decree holder who may not see during his lifetime the real fruits of the decree, the legal representatives of the decree holder also may not live to see the fruits of the decree, and the borrower, having borrowed the money and exhausted all the resources, is never in a position to repay the money, and law of execution is such a miserable thing. So therefore, this in the matter of helping the trade and commerce in the society, the legislature had to think of some speedy method, and they appointed two committees. We are aware of these two committees, and the committee has submitted a report. The committee submitted the report saying that the method now adopted is absolutely laborious, and it's not feasible to depend on the common law in the matter of financing the borrowers, and the interest of the bank must be taken. By this time, banks had been nationalized, and depositors' money, the public money, was the money that was lent to the borrowers. Therefore, the interest at heart of the Union of India, the government of India, was to protect the borrower's money, the depositors, to protect the depositors' money against the borrower's right to dodge the delay and the recovery proceedings. Therefore, Parliament enacted the first Debt Recovery Act, and then the Tribunals Act, and then we have the SURFASI Act. Tribunalization is now the matter in vogue. What we have today is take away the jurisdiction of civil courts and invest the jurisdiction in tribunals, bring about expeditious disposal of the cases, and give all the powers which the civil court enjoyed to these tribunals, so that the rights of the lender, the creditor, is fully secured and the recovery is made fast and quick. There's no parallel to the relief that we give to the bankers compared to what is contained in Securitization Act. We do not have any other law which will protect the interest of the bankers except the Securitization Act. The Securitization Act deals with financial institutions generally. We have a good development in law to say that these financial institutions include cooperative banks, not merely the scheduled banks and the non-scheduled banks, but cooperative banks are also included under the scheme of Securitization Act, and amounts due to the cooperative banks are also brought under this debt recovery tribunal, and the tribunal is authorized to entertain the claims of the cooperative banks and also recover money. This is the greatest advantage that has been extended to the banking sector, and what was missing from the common law aspect is now covered by this Term Financial Institution Securitization Act. Now, we'll have to, enforcement of security is set out in Chapter 3 of Securitization Act, and primarily we have Section 13, 14, and 17, which will deal with the recovery of the property, recovery of the debt. Section 13 authorizes, earlier we had the tedious journey of lawyer's notice, then the filing of the suit, going through the trial with the written statements filed by the borrower saying that they have not borrowed, they do not know the borrower, somebody has borrowed it, not the security is not offered, the security is not offered. All sorts of defenses are taken, and by the time these issues are resolved, the borrower's health would have deteriorated, and his ability to repay the loan would have also failed. The banks would have suffered great loss. And now this Securitization Act has replaced the common law method, and Section 9 of CPC is deprived of the specific jurisdiction to try and recover the suits for recovery of money due to the banks. This change is a welcome change. Now, as I was narrating the scope of Section 13, and the essential section is 13.4. In case the borrower, the notice is to be issued in Section 13.3, and non-payment of the debt within the time stipulated gives the right to the bank to proceed further under Section 4, the subsection 4 of Section 13. 13.4 would say, in case the borrower fails to discharge his liability in full within the period specified in subsection 2, the creditor, the secured creditor, may take recourse to one or more of the following measures to recover his secured debt, namely, take possession of the secured assets of the borrower, including the right to transfer by way of lease, assignment, or sale by realizing the secured asset. The greatest right that is given to the bank is this 13.4. The bank is authorized to take possession of the property, and that is under Section 13.4, Class A, take possession of the secured assets of the borrower, including the right to transfer by way of lease. Then Section 13, Class 4B says the bank is authorized to take over the management of the business of the borrower, including the right to transfer by way of lease, assignment, or sale by realizing the secured asset, provided that the right to transfer by way of lease, assignment shall be exercised only where the substantial part of the business of the borrower is held as security for debt. Then kindly see, we have other provisions like under Order 40, we have the right to seek appointment of a receiver to be in charge of the borrowed, the secured assets, but the borrower's interest to be protected by recovering the money in a prudent manner. That is provided here in Clause C of Section 13.4. Appoint any person, hereinafter referred to as the manager, to manage the secured assets, the possession of which can be taken over by the secured creditor. So therefore, the bank takes over possession of the creditor, appoints a manager to be in charge of the assets for the purpose of managing the property. Then the Section 14B, Section 13, Class 4B, require at any time by notice in writing any person who has acquired any of the secured assets from the borrower and from whom any money is due or may become due to the borrower to pay the secured creditor so much of the money as is sufficient to pay the secured debt. Then kindly see Section 13.5 says, any payment made by the person referred to in Class D, subsection 4, to the secured creditor shall give such person a valid discharge as if he has made payment by the borrower. So interest of the borrower is secured by saying that brings about discharge of the mortgage debt. Then we have the section, this section 13 contains several provisions, and the essential provision is, from my point of view, is 13, subclass 13. No borrower shall, after receipt of the notice referred to in such subsection, transfer by way of sale, lease, or otherwise, other than in the ordinary course of his business, any of his secured assets referred to in the notice without prior written consent to the secured creditor. This is virtually an order of attachment. We have Order 38, Rule 5. Under Order 38, Rule 5, the borrower's assets can be attached, and he shall not deal with the property except in the normal course of business. And with the written permission of the secured creditor. Now, the same Order 3855 is incorporated here to say no borrower after receipt of the notice under subsection 2, that is demand notice by section the bank, transfer by way of sale, lease, or otherwise, other than the ordinary course of business, any of the secured assets also. Then kindly see the objects and reasons for this class 13, which are incorporated subsequently, are really in the Parliament has taken great pains to protect the interest of the bank and see that the borrower's money is taken care of. Section 14, in the next section is section 13, section 14 of the Securitization Act, which authorizes the CMM, City Metropolitan Magistrate, or the District Magistrate to assist the secured creditor in taking possession. Now, the latest decision of the Supreme Court is in the year 2020 that even without the assistance of the magistrate, the bank can take possession of the property and is a secured asset in a quicker manner, without giving discretion to the magistrate to come in the way or delaying the procedure. We can formally go through the magistrate, good enough. If there is any delay or some sort of procrastination, then we, even without the assistance of the chief magistrate, my CMM, they can take that money. Then kindly see, any action taken in good faith is not to be questioned. And the more important or the most important provision in Securitization Act is Section 17. Section 17 is pivotal in the interest in securing the interest of the bank. Section 17 ordains that if you have any grievance, either in regard to the Section 13.2 notice or in regard to 13.4 action taken with the banker to seize possession of the property, the only way for you to help yourself is to go under Section 17 and file an appeal. The term used is file an appeal, but in fact, it's an original proceeding before DRT, Debt Recovery Tribunal. What is it, the right of appeal? So that means it's the jurisdiction of civil court is barred in the matter of ascertaining the disputes in regard to now the act of borrowing and other things. Kindly now in conjunction with Section 17, one has to read Section 34 of Securitization Act. 34 says the jurisdiction of the civil court is barred. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which a debt recovery tribunal is empowered or by other authority in respect of any action to be taken is authorized to recover. You will kindly see that the jurisdiction of civil courts is barred, and this bar is to be interpreted strictly on no court shall entertain. Normally, in the family of borrowers, two situations would arise. This is with reference to the decided cases I am saying. A suit for partition is filed, saying that the borrower has pledged mortgage our joint family property. We are not borrowers, therefore our interest will not suffer any charge on the property. Release the property from the hold of the charge that you have under Section 13 and 14 is a normal suit filed. Then throughout India this has happened. Supreme Court has held very, very in strictest terms that if you have got any grievance saying that the mortgage caused by or affected by one of the members of your family, go to Section 17, have this matter resolved. DRT is authorized to resolve this also. Don't file a suit. That's the best thing that could happen. The second incident of common occurrence is winding up proceedings. The company and our property is mortgaged by one of our shareholders. This is not correct. Wind up the company and distribute the assets to us free from encumbrance. This is also a common thing. On these two aspects, the Supreme Court has very severely come across and said that you have no power. Kindly, I'm citing this. The next common thing that occurs is OTS, one-time settlement. They will file application before DRT that there is a circular issued by the Reserve Bank of India that in order to reduce the NPA, the banks are authorized to reach a one-time settlement and settle the matter recover the money as expeditiously as possible. That circular, which authorizes one-time settlement, is loaded with conditions. The first condition is, if the security offered by the borrower is more and the debt is less, do not go for OTS. If, on the other hand, the amount due, the outstanding amount due in the loan account is huge and the security offered is very less, 1:2, 1:3, then in that event, get the maximum amount possible by one-time settlement and settle the amount, see that the money of the bank is recovered. You have recovered in the course of time some interest, some payment of principal and other things. Yes, take that into consideration and enter into a one-time settlement. The question is this, whether DRT can consider OTS. There are two views. One is, if it is permissible within the guidelines of Reserve Bank of India, namely, intrinsic value of the security is more, the debt is less, one step to be taken. If the security value of the security is less and the dues are more, another permissible way is provided under the guidelines. Therefore, the DRT can do it, is one view. The other view is, don't, and OTS, this one-time scheme is a right conferred on the bank to use in its discretion speedier economical recovery of the amount due. Without that, OTS guideline or OTS scheme is not intended for the benefit of the borrower. Borrower is not given any right to enforce the terms of RBI direction. It had only the bank has the right to enforce that use its discretion and recover money. More often than not, high courts are filled with WPs, writ petitions under Article 226 and 227, where the borrowers, especially in Karnataka High Court, I'm seeing it even now and then, and the borrower says, I am prepared to settle the matter, please give me one term. The writ petition is admitted and further proceedings are stayed and no progress in the writ petition, and each time they say, we want to settle this matter, Lok Adalat. Then this settlement, under section 89 of the Code of Civil Procedure, which applies even to appeal proceedings and which applies in the inherent, affects the inherent jurisdiction High Court, settle this matter, OTS. Now, this Supreme Court has come down heavily saying that OTS is not an enforceable right in the visiting the borrower or residing in the borrower, and all that it does is gives the discretion to the bank to recover the money, and there is not an enforceable right. Article 226 is often used for this purpose, and Supreme Court has held that in 2014, volume 6, SEC page 1, it is held that the exercise of the power by CMM is liable for review, but it is not to be upturned in any other manner. Then you will kindly see that section, the 2019 volume 14 SEC page 788 says the right of appeal under section 17 of the Securitization Act is a valuable right given to you. Do not approach the High Court under Article 226, and High Court is they have used the word, the habit of entertaining 226 question is deprecated, and in spite of our decisions rendered saying that this Article 226 is not meant for the entertaining the borrower's writ petition under Article 226, 141 is violated. You are not following our direction. Please do not stop entertaining this writ petition. Then the next question is, ouster of jurisdiction of the court of civil suit is explained in AR 2016 SC 5140. Equivalent of it is 2017 1 SCC page 53. Then you will have to particularly OTS, I was mentioning, right? And that decision has been, the OTS scheme was sanctioned by the High Court under Article 226. Directions were given to the bank saying they settle this matter. The matter went up to Supreme Court, and Supreme Court in the decision reported in 2016, volume 16, SEC page 596 has held that OTS is not enforceable right, and you cannot seek writ of the mandamus to the bank to settle this matter. I think number of decisions are there, and we should be very cautious about this matter, namely that 226 should not be misused or abused in this manner. Please see, now we'll have to fall back on the earlier provisions as to how this Securitization Act is made applicable throughout India. While I am on the subject, I thought I should make use of this to say that in state of Jammu and Kashmir, the State Securitization Act as a whole was not applicable. When in 2017, you will remember, Securitization Act was the scope, the application section 17 was also applied to Jammu and Kashmir, and the writ petition was charged. The High Court of Jammu and Kashmir accepted the challenge made to saying that Jammu and Kashmir is protected under Article 370 and 35A. Therefore, they are not of being brought under the Securitization Act. They must file the suit. They must suffer the contesting the suit. They must file the execution and leave to realize the debt recovery of the amount lent. Fortunately, this is undone in the year 2017, and that was also tested by the petition before High Court of Jammu and Kashmir accepted this challenge and set aside the amendment extending the application of Section 17 to our Securitization Act to the state of Jammu and Kashmir. The matter is now settled by Supreme Court, saying that Jammu and Kashmir is Article 1 says Jammu and Kashmir is an integral part of India. It's only some of us feel that Jammu and Kashmir is not an integral part of India, and Supreme Court has said the Securitization Act is applicable. And this is one of the instances which went into consideration of His Excellency the President when, under Article 370, Clause 3, promulgation was made on 5/8/2019, diluting Article 370. Article 370 has been diluted, therefore, Securitization Act is applicable to Jammu and Kashmir also. We'll have to see now what is the role of taking the bank in taking over the management. What is its power and how is it can maintain? If switching over from banking business to managing a running business, this has been done because a committee is supposed to be appointed, and the technical committee would advise the bank as to how the bank has to manage its affairs. So many things have happened. Securitization Act has brought about a sea change in the matter of recovery of the bank's dues. Well, we have to ask ourselves this question. We have Vijay Mallya, we have Nirav Modi, we have Subrato Mukherjee, we have several institutions which have misused and abused the provisions of Securitization Act and Article 226, and they are merely enjoying hours of the deposit. Now, if all the monies are recovered from these celebrated borrowers and glorified defaulters, the bank would be in a different situation. The bank would have the money to advance to other needy persons. We have only, unfortunately, we have the one decision which is rendered by a lady magistrate in London, which was considering the application for extradition of Vijay Mallya, and this is what the Honorable Supreme Court, this is what the magistrate has said. The name is Emma Arbuthan. That magistrate has passed this order. Judge Emma Arbuthnot, Chief Magistrate at Westminster Magistrates Court at London, ruled that the 62-year-old businessman had a prima facie case of fraud and money laundering to answer, and ordered extradition of Mallya, wanted for alleged bank fraud and money laundering amounting to an estimated 9,000 crores. The judge was extremely critical of Indian banks, expressed her shock at the failure to obtain proper credit reports before certain loans were sanctioned by some of the state-owned Indian banks. The judge described as continuing failure of banks and said it remained unclear from the evidence before her if these were by design or with hidden financial motive. Or it's a case of banks who are in the thrall of this glamorous, flashy, famous, visual, bodyguarded, ostensibly billionaire playboy, Vijay Mallya, the reference is Vijay Mallya, who charmed and cajoled these bankers into losing their common sense and persuading them to put their own rules and regulations to one side. She said in one of the most critical statements in the judgment, if the criteria for lending to Kingfisher Airlines had been applied, if the background checks had been carried out, and the loan should not have been granted, she noted. It's in an addition, that's in an indication that some bank employees may have involved in a wider conspiracy. The judge concluded she did not find prima facie case of conspiracy to defraud, which involves not just Kingfisher Airlines executives, but also some bankers at the Industrial Development Bank of India who were named in the Indian government case. Our government came into the severe criticism, and there are in another proceeding, I could not lay my hands on that proceeding, there is mention of the then finance minister and the then chief prime minister of India who had written letters to the banks, 6 banks, give him loan. And this creditworthiness was not updated, and he was not found to be eligible for loan at all. But the political pressure allowed the banks to not allowed, pressurized the banks to give money to this fellow, and our money, the depositors' money, is in the hands of this playboy. So we'll have to now see what is the in some effect, the effect of the mortgage, the common law right of the mortgage of properties, creating security in the context of the banking law. The banking law is tougher than the procedure allowed in civil law or the Law of Contracts Act, and the procedure involved in the common law procedure, namely Section 9 CPC, ending with execution proceedings, is certainly laborious, painstakingly elongated, and unproductive. It involves additional cost in the form of court fee, advocate's fee, and several other expenditure. The witnesses have to come from the Assam to give evidence in Bangalore. His airfreight, his stay in Bangalore, all these things were ready. Securitization Act has removed all these difficulties and has given the power to the bank manager, who issues notice in the Section 13(2), takes possession of the property, deals with the property, puts his own man as the manager, as the receiver of the property, and realizes the money. Now, to sum up my narration, I will only say that the common law right of mortgage, the common law right to recover the bank dues on the basis of the security offered by the borrower, namely the mortgage property, that is inferior in quality, inferior in content, and far laborious compared to the Securitization Act, namely the banking law. Banking law has now become, in a prismatic sense, I would only say it's a gem of a relief to as far as the banks are concerned. And if only the banks are in a position to use these provisions, limits, Section 13, 14, and 15, and be very strict in regard to the right under Section 17, the bank's purpose is served and the depositor's money is safe anytime. The common law, the right under the mortgages is to be forgotten, and that security only in the form of equitable mortgage by deposit of title is to be enforced. The banks will have to survive on deposit of title deeds and recovery in terms of Section 13 and 14. I sum up and say that the common law rights are not to be adopted anymore, and the common law remedy was good enough for the olden times when banks were few, lending was far in between, and the recovery was never resorted to the court. They were saying, though under common law itself, the bank has the right to recover money, it's loaded with trouble, and therefore they don't resort to it. That now specific right is given under Securitization Act, we are in a better position. Our money is safe in the hands of the bank, notwithstanding several Vijay Mallyas, several Nirav Modis, several Subrata Mukherjees, and I'm not exhausting the list. There are ever so many people who are borrowing our money, deposits money, and now kindly look at what's happened to the cooperative banks. several people have borrowed money from the cooperative banks, and the hard-earned money, the life savings of the senior citizens are now at the altar of being lost. The situation is so bad that cooperative banks have lent money indiscriminately, and cooperative banks are in trouble. Something has to be done about this. Reserve Bank of India has to step in. Now it's also an ordinance is passed. The law is also passed to say that the Reserve Bank of India can apply Banking Regulation Act even to cooperative banks. So and societies also would come into that. If the situation is wholly changed, and in course of time, the deposits would be in a proportion to say, yes, our money is safe. Thank you very much. Mr. Vikas? Yeah.
Yes, sir. You have took the entire length and breadth of the session on the law of mortgage. And one question so far has come. Yeah, when IBC Code 2006 is in existence, what is the role of SARFAESI Act? Is it not overlapping act?
Section 206 of the Indian Penal Code
authorizes... No, sir, IBC Code.
Yes, the Indian Penal Code. Indian Penal Code, IPC. See, criminal action is only to...
No, sir, IBC. Insolvency and Bankruptcy Code. In fact, I have been...
Sorry, I did not...
No, in fact, I got... till I could read the question, somehow I got myself muted. Therefore, I could not answer it. Yeah.
Please. See,
yeah. The question is on Insolvency and Bankruptcy Code.
Bankruptcy Act is a coercive measure. It is intended to raise the whip and threaten him with the bankruptcy proceedings to enable him to repay the money. But the real recovery is in this Securitization Act. There is no conflict between the two. Securitization Act enables recovery in an effective manner, while the Indian Bankruptcy IBC is only a coercive enactment to say it's a threatening provision. See, nobody wants to lose the status of a creditworthy person. Creditworthy person is one who will not allow his prestige to fall down. So therefore, that's a quick fix relief. IBC is a quick fix relief, while Securitization Act is a sure relief to recover money.
Yeah.
Quick fix relief. It is not a lasting relief. It's a, for example, if he can, there are routes for him to escape from IBC also. But under the Securitization Act, there is absolutely no chance for escape.
This is whether mortgage property is necessary for attachment under Order 21, Rule 54.
No. First, basically, mortgage property shall not be attached again because there is already charges created on that. So therefore, there's no need to additionally or the further attachment for purpose of bringing it for sale. In fact, under the provisions of Order 21, Rule 54 to 66, there is enumeration to say property mortgage need not be attached.
Yeah.
Mortgage property need not be attached.
Prashada Abkari, an agreement for sale holder whose sale deed for the flat is not yet registered, and such sale deed would be registered in future. That is after around 4 to 5 years. In such a situation, can the agreement of sale holder create a mortgage in favor of a bank? In such a situation, in case of default, can the bank initiate SARFAESI Act proceedings?
Agreement to sell does not create an interest in the property. I think it is 1966 or 67 Supreme Court, page 740. The decision of the Supreme Court is that a mere agreement to sell does not create an interest in the property, and he cannot transfer that interest. Agreement to sell does not create an interest in the property, he cannot sell. He cannot create a deal with that right.
This is can the bank take physical possession without the aid of the magistrate? He's saying, Mr. Anurag Jain, as to whether the provisions of section 14 would apply or not. Is
Now,
it required?
recently, Supreme Court has held that even without the assistance of the magistrate, the bank can take possession under section 14. That was in the month of September.
This is one question by Madhukar was, does financial bank follow the circulars of RBI?
Can the financial?
Does the financial bank follow the circulars of RBI?
Yeah, the
Sardar Associates is an answer to that. It says yes. If there is an OTS by the bank, it is applicable.
It is applicable to a bank, whether scheduled bank or non-scheduled bank. It is applicable. No, a cooperative bank is also governed by RBI, this Banking Regulation Act. RBI circulars are binding on the bank, but it doesn't give a right to the borrower to enforce. It's a strict jockey formula for the banks to follow the RBI directives. They shall not violate the RBI directives. Section 42 of the Banking Regulation Act says directives issued by the RBI shall not be followed, shall not be disobeyed, shall not be violated. 42 of the RBI Banking Regulation Act.
In fact, they nowadays have started writing it after the judgment of Sardar Associate. It is non-discriminatory and not non-discretionary.
Well, that's the view. That's one of the views.
Yeah. This is by Priyanshu. He says, Priyanshu Kamra, OTS entered between the bank and the party. Subsequent lockdown due to pandemic, bank cancelled the OTS. What can be the remedy, sir?
Section 17 only. He has to go to Securitization Act and file an appeal saying that yes, this is an extenuating situation to reduce the time given for repayment and also to provide for terms of easy payment. Doesn't have the right to abrogate the loan or say that loan is discharged by reason of this. If that is so, throughout India we have got this political party waiving the loan. This is going to kill us in future. The political parties cannot waive the loan, and we will have a lot of difficulty by this. And again, if it has to come, it has to go to DRT and register the rates.
I'm just checking as to whether we have any question on Facebook. No. Sachinanand has explained, if obstruction is there, without the assistance of magistrate, the bank cannot take possession. Police assistance will be provided only on the orders of the magistrate. Section 14 is explicit to that effect of the Securitization Act.
That's a requirement of law. Magistrate has to authorize, because see, if the bank on its own enters the premises of another person, presumed trespass, therefore to obviate a criminal offense being committed, the magistrate intervenes and matters authorizes. This is conventional.
This is by Prabhat Singh Mahida. Mortgager died and it is felt to rectify the mortgage. One of the legal here is minor. What is the remedial action?
Through the guardian, it can be done. If it really requires rectification, the minority of one of the warriors is not a bar. It can be done through the assistance of the court.
This is, so we don't have the, okay. This is by Jaisima. What is to be done when there is a delay in passing of the orders under section 14 by the DM or CMM?
Article 226. You can go to Article 226 and 227, get a direction.
There's a judgment by a detailed judgment in the Bombay High Court by Justice Chandrachud, and there's one judgment of Justice Suryakant of Punjab Haryana High Court, which says that where it has to be done, what time has to be complied with.
Yeah, that's also true. Yes.
Yeah. It says that you can ask for a direction, and then the courts have said you have to regulate in a particular manner. Dr. Madhukar can contact me. I will give the side. I will share the judgment with him. So we don't have any other questions. I'm just waiting for tomorrow's webinar. Tomorrow's webinar is on pleadings, Code of Civil Procedure, as well as the Arbitration Act. Justice N. Kumar, former judge of Karnataka High Court, he would tell us the subtle differences between the pleadings, the arbitration proceedings, vis-a-vis the civil court procedure. So do stay connected with us tomorrow at 4 p.m. with Justice N. Kumar, the former judge of Karnataka High Court. And his previous webinar on this platform has already gone viral. And before we part for the day, I, on behalf of all the participants on the Facebook and on this platform, we thank Mr. S.P. Shankar, a senior advocate of Karnataka High Court, who has explained a difficult topic in a sublime manner, which could be understood by everyone. On behalf of everyone, thank you. And to all the participants, stay safe, stay blessed. Namaskar. Jai Hind. Thank you.